Let's roll, nerds. You said 16?
Yes.
Good morning, Mr. McLean. Sir, you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, sir. An officer initiated a traffic stop in Harris County, Texas, after observing the defendant exceed a speed limit of 45 miles per hour and make unsafe lane changes. The defendant did not have his driver's license, but told the officer his name and date of birth. While the officer was running the defendant's name, he observed the defendant exit his vehicle, and the officer told the defendant to get back inside the vehicle. And the defendant responded, "Do I have to?" The officer exited the vehicle and attempted to detain the defendant. The defendant tensed up and locked his arms.
Everything is conclusory. And what has he done wrong? What?
Okay, this is where things get interesting. The judge is basically asking, where's the actual crime? Speeding in a lane change explained the stop, but not the arrest. So now the spotlight is on whether simply stepping out of a car can legally count as interference. What do you think? Should that be enough to get arrested?
Okay, in a what?
Sorry?
In a what? I mean, if it's on 610, he's fine, right? And then he's interference duties. What is he interfering with? What did he do wrong?
I think it was after the stop was initiated, the officer was running the plates. The defendant stepped out of his vehicle. The officer told him to get back in the vehicle. The defendant said, "Do I have to?" The officer told me.
Wait, so the interference is literally him asking, do I have to? That's a huge legal gray area. Questioning an officer isn't automatically a crime. This is exactly why probable cause matters. Without a clear violation, the whole case starts falling apart.
And Your Honor, furthermore, as he was attempting to detain him, he locked his arms and tensed up. So as he was attempting to detain him, following that incident of him telling him to get back in the vehicle. And it was
That's the basis for arrest.
it was just a temporary detention. He was just attempting to detain him while he was trying to
What's he
investigate.
doing wrong?
Yeah.
What's he doing wrong?
65. Yeah.
No, I don't think so. You can find no probable cause. No, it's just, he gets out of the car and then it just the virtue of fact him getting out in the car is interfering with the duties. Really? No. Just, when you get into, just be careful out there, man. Life is hard as it is. When you get into, gotta be careful, man. People are always out to get you.
And there it is, the turning point. The judge is basically saying, this doesn't hold up. No clear crime, no solid interference, no probable cause. This is a classic example of how a weak arrest can collapse under scrutiny. Lesson here? Knowing your rights and staying calm can completely change the outcome.
Up to 6 months in jail and/or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, will be appointed to you.
The position of the state judge is that did obstruct their investigation. I mean, it's not in this. There's multiple senses of obstruction in our opinion. It's not.
Are you losing right now?